hosting the ICC Moot Court Competition 2024 English edition. Please be seated.
Good morning, all. This time with the microphone. Please allow me to introduce the bench. To my right is Roger Bartels, and to my left, Farhan Ahmed, and I am Judge Althea Alexis Windsor, and I will be presiding over this hearing this morning. I'd like to greet the teams participating: Counsel for the Prosecution, Common Legal Representative of the Victims, and Counsel for the Defendant. Allow me as well to welcome the courtroom staff, security officers who continue to assist us in our work. I should also like to greet all of the very many people who are here in the public gallery. The participants in the ICC Moot Court competition attending this hearing, and those outside the court joining us today via the internet in this Moot Court competition. Court officer, please call the case.
Thank you. We are sitting in the appeal session regarding the pretrial chamber's denial of confirmation of charges in the case of the prosecutor versus Lionel Strong in the situation in the Republic of Syriac ICC Moot Court Competition 2024 English edition.
Before we begin, there are some instructions that I should like to give the parties and participants. 1, speak slowly. 2, pause before responding to any question in order to allow all of the participants and parties to follow closely, as well as pay attention to your times. All right, I'd now ask the parties and participants in this hearing to introduce themselves, beginning with counsel for the prosecution, who brings this appeal.
Judge President, Your Honors, may it please Honorable Court, good morning. My name is Mr. Albert Masharia, counsel appearing on behalf of the OTP, and I'm accompanied by my co-counsel, Mr. Johnny Kiteka. Thank you.
Thank you. I now turn to the common legal representatives of the victims participating under Article 68(3) of the Rome Statute. Could I ask you, counsel, to present the members of your team?
Good morning, Madam President, Your Honors. My name is John Hoy, and I am the common legal representative of the victims. With me today is my off-counsel, James Kwok.
Thank you very much. Counsel for the defendant, could I ask you, counsel, please present yourselves.
Madam President, Your Honors, good day. My name is Samantha Villanueva, and I represent the defendant, Lionel Strong. Together with me is my co-counsel, Jeremy Tan. Thank you.
Thank you. The registry today is represented by the court officers Laura Pereira and Mariana Foyo Lopez from the Grotius Center for International Legal Studies. All right, so the chamber will now proceed with the 3 issues shaping the subject matter of today's hearing. Being mindful of the public nature of this hearing, I would ask the court officer to please read the agenda established by the Appeals Council, the Appeals Chamber.
Thank you, Madam President. Pursuant to Pretrial Chamber 15's decision to grant the prosecution's request for leave to appeal the denial of confirmation of charges of 15 May 2023, the Appeals Chamber seeks submissions of all parties and participants on the following 3 issues. A. Whether the pretrial chamber erred in holding that the ICC lacked jurisdiction over the defendant because the Republic of Syriac had withdrawn from the Rome Statute under Article 127 of the statute, despite the prosecutor's public announcement of a preliminary examination prior to the effective date of Syriac's withdrawal. B. Whether the pretrial chamber erred in holding that the allegations of evidence are insufficient to establish substantial grounds to believe that the defendant committed attacks on historic monuments in a non-international armed conflict under Article 8, Paragraph 2, Subparagraph E4 of the statute, or the crime against humanity of persecution under Article 7, Paragraph 1, Subparagraph H of the statute. C. Under the pretrial chamber, that whether the pretrial chamber erred in holding that the defendant was not fit to stand trial under Article 64, Paragraph 2 of the statute and Rule 135 of the Court's Rules of Procedure and Evidence.
Thank you. Thank you, Court Officer. I now turn to the prosecution. Please present your submissions.
Judge President, Your Honors, good morning again. As earlier on introduced, my name is Mr. Albert Masharia, counsel appearing on behalf of the prosecution. Your Honors, the case of prosecutor versus Mr. Lionel Strong stands as a poignant reminder of the degree of human suffering and atrocities committed within the territory of the Republic of Syriac. This case is a representation of more than 800 individual lives that were lost, as well as the desecration of the Tirosh archaeological site. However, and most importantly, this is a case about abuse of process, whether states, like the Republic of Syriac in this case, can withdraw from the Rome Statute in a quest to escape accountability of this court and protect perpetrators of impunity. And as the prosecution, we submit that this cannot stand. And this is why we bring forth this appeal on 3 crucial grounds. That the pretrial chamber on the 15th of May 2023 erred in holding that, first, this court lacks jurisdiction owing to Syriac's effective withdrawal from the Rome Statute. And that second, that it erred in finding that there was a lack of substantial grounds to believe that a crime under Article 82E4 as well as Article 7.1H had been committed. And lastly, contrary to the pretrial chamber's finding, we will submit that the defendant in this case is indeed fit to stand trial. However, Your Honors, before we begin our submission, it's important to recognize the court we are in today, the appellate chamber. And it's important, Your Honors, because it sets the standard of appellate review that will be guiding this discussion. And the standard of appellate review pursuant to Article 83.2 of the Rome Statute is that this court will concern itself on the analysis of whether there was a material error of law, fact, or procedure. And where such error exists, we shall ask this court to reverse the decision of the pretrial chamber pursuant to Rule 1581 of Rules of Procedure and Evidence. With this in mind, we'll begin our first submission. Article 19.1 of the Rome Statute places a solemn duty of this court to satisfy itself of the 3 types of jurisdiction. However, pursuant to page 1 of the record, this appeals chamber has requested submission on whether it lacks jurisdiction owing to Syriac's effective withdrawal. And we submit that indeed this court can exercise jurisdiction based on 2 primary grounds. First is that at the time of commission of the crimes in question, the Republic of Syriac was still a state party to the Rome Statute. And second is that there was a matter under consideration before the effective withdrawal of the Republic of Syriac from the Rome Statute. Beginning by substantiating our first point of our submission, the starting point of our consideration is Article 11.2 of the Rome Statute that asserts that this court shall assume jurisdiction over all crimes that are committed after the entry into force of the Rome Statute. In this case, pursuant to paragraph 4 and paragraph 7 of the background, as read as together with paragraph 7 and 8 of Annex C to the record, the crimes in question were committed between the 8th and 9th of June 2021 before the effective withdrawal of the Republic of Syriac. However, Your Honors, we acknowledge the rights of states to withdraw under Article 127 of the Rome Statute. And we submit that indeed there was a matter under consideration under the auspices of Article 127.2 of the Rome Statute. An analysis of Article 127.2 of the Rome Statute would show two things, Your Honor. First is that the OTP is part of the court as under Article 127.2. And second is that a matter under consideration under Article 127.2 of the Rome Statute can be interpreted to include preliminary examination. Your Honor, the guiding parameter of interpretation of Article 127.2 of the Rome Statute is the Vienna Convention on the Law of Treaties, in particular at Article 31. And this has been established to be the standard method of interpretation by the Katanga trial judgment, in particular at paragraph 46. And pursuant to Article 31 of the VCLT, this court shall consider the following: the ordinary meaning, the context, as well as the object and purpose of the provision in question. Your Honors, we'll begin by the context of Article 127.2 to make a case that the OTP is part of the court, and that a preliminary examination launched by the OTP should actually amount to a matter under consideration. Your Honor, the first contextual element we guide this court to is the first limb of Article 127.2 of the Rome Statute, that states that states have post-withdrawal obligations with regards to criminal investigations with the court. Now, pursuant to Article 42 of the Rome Statute, the role of criminal investigation can solely be undertaken by the OTP. This would show that the interpretation of the word court under Article 127.2 was actually meant to include the OTP as part of the court. But even further to this, to support this interpretation, we rely on the object and purpose of Article 127.2 of the Rome Statute, which can be evidenced by the drafting history, in particular draft Article 98H that informed the present Article 127.2 of the Rome Statute, that stated that the object of Article 127.2 of the Rome Statute is to make sure states, like the Republic of Syrax in this case, do not escape accountability through withdrawal. And this, in fact, would be in light with the overall purpose of the Rome Statute, that of ending impunity. Your Honors, in light of these two considerations, we submit that the word court is actually meant to include OTP as part of the court under Article 127.2 of the Rome Statute. The next step is to determine whether No, Your Honors. In fact, as noted by the OTP's policy paper of 2013, the OTP does not enjoy investigative powers with regards to, the state does not have an obligation to cooperate with the OTP at the preliminary examination stage. However, we'd like to remind this court that the existence of obligation to cooperate is not a precondition to the exercise of jurisdiction, and this has actually been clarified in the Philippines Article 18.2 decision. And in this case, we do submit that when a matter under consideration exists, it is inconsequential on whether there is an obligation to cooperate with the court. And we submit that a preliminary examination can be a matter under consideration. And we place reliance in the Article 15.3 decision in the situation in Philippines, in particular at paragraph 111, where the court found that it could retain jurisdiction, particularly because the preliminary examination in the situation in Philippines had been launched before the effective withdrawal date of the Republic of Philippines. And in fact, the court goes a step further to cite the provisions of Article 127.2 of the Rome Statute, in particular at footnote number 235. However, we preempt the defense may argue that this cannot stand because of the majority opinion appealing Article 18.2 decision. However, we submit that this is the most probable interpretation, the most favorable interpretation under Article 127.2. For this interpretation would be in light with Article 21.3 of the Rome Statute that requires the interpretation of the Rome Statute to be in line with the recognized international human rights standards. And therefore, Your Honors, we submit on this basis that indeed this court has jurisdiction. Turning to the second issue of appeal, pursuant to paragraph 6 of the record, the subject matter of appeal under crimes under war crimes under Article A2E4 was whether there are substantial grounds to believe that a crime has been committed. And in arriving at this conclusion, the pre-trial chamber focused on the fact that the type of conflict in the Republic of Syriac was not a non-international armed conflict. However, Your Honours, we submit to the contrary, that the pre-trial chamber erred in finding that the conflict was not of a non-international armed conflict nature. A non-international armed conflict, as defined in the Interganda trial judgment, refers to protracted armed violence between governmental authorities and armed group in question. The standard here is that of Common Article 3 as opposed to that of Additional Protocol 2, that requires two legal requirements to be met. That first, the group in question must be sufficiently organized. And second, that the intensity of the conflict must be sufficient. And we submit that these two requirements have been met in this present instance to qualify the type of conflict in the Republic of Syriac to be an international armed conflict. Beginning with organization, it's important to note the threshold applicable in this case. And the threshold applicable in this case while assessing organization has been laid out in the Katanga trial judgment, which is the standard of relative organization that requires that, at the very least, the armed group in question must be able to participate in armed hostilities. And indicators to show organization, the several indicators to show the organization nature of the group in question, such as command organization, leadership, command organization, logistical organization, military operation organization, as well as discipline and unified voice organization. In this case, we submit that these factors do indeed exist. Pursuant to paragraph 7 of Annex C to the record, Ms. Alinda Jasper has been pointed out to be the sole authority, to be the central authority of the Karaxis fighters, meaning that she is the leader of the Karaxis fighters. However, Your Honours, while assessing the leadership organization of the group of an armed in question, of importance is the practical functioning of this leadership organization, which, as indicated in the case of Prosecutor versus Dominic Ongwen, will be indicated by generally following orders given by superiors. And in this case, Ms. Alinda Jasper issues a call to action to the Karaxis fighters, and pursuant to the call to action directed towards the Karaxis fighters, more than 800 armed individuals show up and adhere to this call. Your Honours, this shows one thing, that the leadership organization of Ms. Alinda Jasper was practically functioning. However, we preempt the defense in this case may argue that there is a need for a chain of command, as well as existence of internal hierarchies. However, pursuant to the Katanga trial judgment, in particular at paragraph 1149, the fact that the Walendu Bindi did not have a centralized command structure, the court did not find that they were not organized. And therefore, we do submit in this case that there is no legal requirement that there must be a chain of command in the group in question for the group to be sufficiently organized. The second factor we point to show the organizational nature of the group is the logistical organization of the group in question. And the logistical organization of the group in question can be indicated by several indicators. For example, the first one is the ability of the group to recruit its members. In this case, pursuant to paragraph 5 of Annex C to the record, the group in question has the ability to recruit its members, amassing up to 100,000 membership in its group. But even further to this, the group has the existence of visual identifiers, evident in paragraph 7 of Annex C to the record, that the group, in fact, has armed bands with dragon insignias, adding to the visual identification, which is an indicator of logistical readiness. And the last indicator we show that, in this case, is a possible inference of the existence of training within this group in question. And we submit in this case that pursuant to paragraph 8 of Annex C on the record, the fact that the Karaxis fighters could engage in exchange of gunfire does mean that the group in question actually received some degree of training. And we'd like to draw a parallel in the case of Prosecutor versus Radinaj, where the villagers in the Dukatjin region were found to operate firearms. And in actually finding that there was existence of a level of training, the court did infer that operation of firearm implicitly indicates that there was some degree of military training. And Your Honours, as I conclude in this case, the standard of relative organization does not require that the armed group in question have a sophisticated degree of organization. All we require is that at the very least, the group in question should be able to participate in armed hostilities, which has been met in this particular instance. Turning to the second point of consideration under an international armed conflict, that of intensity. As indicated in the Lubanga trial judgment, in particular at paragraph 537, indicators of intensity include the following: the increase in governmental forces or increase in number of combatants in the conflict region. In this case, pursuant to paragraph 8 of Annex C to the record, there was addition of 2,500 municipal forces as well as the addition of 1,200 Karaxis fighters. This speaks as to the escalating nature of the conflict in question. The second indicator is the type of weaponry used, which is clarified in the case of Prosecutor versus Limaj. We must consider the type of weaponry available to both parties in this case. And in this case, heavy weaponry such as the use of RPGs indicates the intensity of the conflict. And in fact, Your Honors, if you may remember in the case of Abugada, the splinter forces did use RPGs. And actually, this was an indicator of sufficient intensity in the conflict. However, we preempt that the defense may argue of the requirement of the protracted nature of the conflict. And to this point, we do submit that the ICTY in the Tadic appeals decision in the year 1999, in particular paragraph 519, has interpreted the standard of protracted to include not only duration, but other assessments of intensity factors, which, as argued by the prosecution, does exist in this case. And therefore, Your Honors, while assessing intensity in this case, we're not limited to duration, but this court can go a step further and look at the other factors. And on light of this, we do submit that the fact requirements of a non-international armed conflict are met in this case. There is a non-international armed conflict, and the pre-trial chamber did err in its analysis. Summarizing on crimes against humanity, pursuant to paragraph 6 of Annex C to the record, the point of contention in this case is whether the contextual elements were met, and in particular, whether the attack was directed towards a civilian population, and second, whether the attack directed towards a civilian population was actually systematic in nature. We submit in this case that the object of the attack in this case was the Karaxis party as a whole, as opposed to the Karaxis fighters. And the guiding law in this case is Article 50 of Additional Protocol 1, that states that civilians are those who do not engage in active hostilities. And the presence of persons who engage in active hostilities within a civilian population will not extinguish the civilian status of the population in question. This has actually been clarified in the Interganda trial judgment, in particular at paragraph 668. And therefore, the defense cannot argue in this case that the fact that the Karaxis fighters were armed in this case would extinguish the civilian status of the Karaxis party as a whole.
Counsel, can I interrupt you there? We've just listened to you arguing that the Karaxis fighters were part of an armed group, sufficiently organized during a sufficiently intense episode of fighting for it to warrant a classification as non-international armed conflict. But now you're saying that those same persons were civilians, not being armed, or even though they were armed, not taking a direct part in hostilities? How do you reconcile those two statements?
In this case, we submit there's a distinction between the Karaxis fighters who engage in armed hostilities and the Karaxis party as a whole. In fact, paragraph 7 of Annex C to the record does identify the Karaxis fighters who are the armed group in question. However, when you look at paragraph 5 of Annex C to the record, Karaxis party is the whole group which also encompasses of the Karaxis fighters. And therefore, in this case, we do submit that the attack was actually directed towards the whole group as opposed to the armed group in question. And our submission in this case is that existence of the Karaxis fighters who are armed in this case will not extinguish the civilian population status of the Karaxis party as a whole.
But then I'd like to get a clarification. If the existence of some armed fighters amongst the civilian population does not change the character of the group as a whole, how does that work in this situation when, based on the facts, every single victim or every single casualty was in fact a fighter, at least according to your argument in relation to the non-international armed conflict? Isn't the entire body of persons being attacked then consistent of fighters rather than civilians?
Your Honors, with regard to the victim status, that is not within the scope of the prosecution submission. However, what we do submit in this case is that the victims in this case are the Caraxes party as a whole. And the reason that the victims in this case was because the attack in this case is not a military operation, but rather the attack in this case is the systematic state policy geared towards the destruction of the Tirosh culture, evidenced by actions such as the ban of the Caraxes party to participate in national elections, the branding of the Caraxes party as terrorist. And therefore the attack in this case is not only limited, is not focused on the military operation, but rather on the non-military operation in this case. And Your Honors, I note that my time is almost up. Could I kindly summarize on our last issue on fitness to stand trial? In this case, Your Honors, we submit that the pre-trial chamber did err based on two grounds. First is that it applied an incorrect standard of meaningful participation. And second, that the pre-trial chamber was wrong to terminate the proceedings, which is contrary to Rule 135(4) of Rules of Procedure and Evidence. Regarding the standard applicable for meaningful participation, the pre-trial chamber did only focus on the two available capacities of the accused in this case, the lack of his capacity to instruct counsel and the lack of his capacity to testify. However, as noted in paragraph 5 of Annex D to the record, the accused person in this case had actually other capacities, such as the ability to retain information regarding the proceedings and to understand the consequences of the proceedings. And an overall analysis, Your Honor, I know that my time is up. Could I request for 1 minute to summarize our submission? Thank you. And Your Honors, an overall analysis of these factors would show that at the very least, all we require is that the accused must be in a position to meaningfully participate in the trial. And as clarified by the RMCT in the Kabuga Appeals Chamber, in particular paragraph 27, the degree of memory required to effectively participate in a trial is that of a proper functioning memory, which as described in Kabuga entails the following: the ability to retain information of the proceedings, which in this case has been met pursuant paragraph 4, where Mr. Lionel Strong is a lucid and articulate man. Second, he must be able to understand the consequence of the proceedings, which in this case, pursuant paragraph 5 of Annex C to the record, Mr. Lionel Strong can understand the proceedings. And lastly, based on retention of information of the proceedings, he should be in a position to instruct counsel. And all these factors have been met in this case. And therefore, Your Honors, we submit that he is fit to stand trial, and that the standard of recollection in this case is a higher standard, and the standard in this case should actually be one of retention. And we thank this court for its time, and we conclude our submission pending rebuttals. Thank you, Your Honors.
Yes, counsel, go on.
Good morning again, Madam President, Your Honours. For the 800 protesters who died at the site, life without their culture was not a life worth living, and the man responsible for the destruction of the site and the deaths of the protesters is the defendant, Mr. Lionel Strong. Now, the lower court had terminated the proceedings against Mr. Strong, and key to that conclusion was their finding that Mr. Strong is unfit to stand trial. I note also that the prosecution earlier only briefly canvassed the issue on fitness, and in that regard, I will first submit on the issue of fitness, where we argue that Mr. Strong is fit to stand trial. Second, that this court does have jurisdiction in this case. And lastly, that there are substantial grounds to believe that Mr. Strong is individually responsible for the war crime of attacking protected objects and the crime against humanity of persecution. I turn to the issue on fitness, where we acknowledge today that the court faces a difficult task of ascertaining Mr. Strong's fitness, but ultimately, the court must be satisfied as to Mr. Strong's fitness, and in that regard, there is insufficient evidence before this court today to guide the court to the conclusion that Mr. Strong is permanently unfit to stand trial. Now, the defense relies on the report by Dr. Mele Belleron, which can be found at Appendix D of the facts. Now, they argue at paragraph 83 of their written submissions that Dr. Belleron's findings should be given due weight because the methodology that she used is within her professional discretion. Now, we can accept that Dr. Belleron has the discretion to decide what test to use, but what the defense has failed to recognize is that there are three key deficiencies within Dr. Belleron's report. Now, in the 2011 Extraordinary Chambers of the Courts of Cambodia, or ECCC case of Ing Trith, the court similarly dealt with a situation where the accused had alleged memory loss. Now, in that case, the court had concerns that the accused was feigning her memory loss, but their concerns were ultimately resolved because the experts in that case had stated specifically what tests they had used and that these tests were designed to exclude the possibility that the accused was feigning her memory loss. Now, Your Honours, in stark contrast, at paragraph 4 of Dr. Belleron's report, at the first line, she makes a reference to a battery of diagnostic tests. Our submission is that this description of the test is too vague and does not provide sufficient guidance for the court today to be aware that Mr. Strong is indeed not feigning his memory loss. Now, further, we note at paragraph 4 of Dr. Belleron's report that she states she made one in-person examination of Mr. Strong. Now, this can again be compared to the case of Ing Trith, where the experts there had made 2 in-person visits, and this was significant because it allowed them to do a comparison of the accused's performance on certain memory tests over a period of time, and this allowed them to conclude that her memory was indeed deteriorating. But in stark contrast, Dr. Belleron only made 1 visit to Mr. Strong and in fact prepared her report on the very same day that she had examined Mr. Strong, and therefore there's insufficient basis for her findings in her report.
Counsel, if I may, is the CLRB challenging the expertise of Dr. Belleron?
No, Judge Ahmed, we are not challenging the expertise of Dr. Belleron. After all, at paragraph 2, she is a court-appointed psychiatrist who has a lot of experience in this area. What we are challenging today is that she needs to provide more evidence and more details in the report before this court can be guided to the conclusion that Mr. Strong is indeed permanently unfit to stand trial, and that this court can do a comparison of her report with reports tendered in previous cases before other tribunals, like in Ing Trith, where the accused also alleged memory loss. Now, because of that, we argue that these inadequacies show the court that the report is insufficient and the court cannot be satisfied that Mr. Strong is permanently unfit to stand trial. And for this reason...
Sorry, if I may. Has this court or any other court set aside an expert's report on the basis that it was inadequately reasoned?
Indeed, before the ICTR tribunal in the case of Karimera, the court had also set aside a medical report because it was inconsistent and also because it lacked pertinent details to the matter at hand. And therefore, we say that this court can take guidance from such cases and also take guidance from the cases of Ing Trith as well as the case of Kabuga, where the court had found that based on the evidence before it, there was insufficient evidence to show that the accused was permanently unfit to stand trial and that more tests and perhaps clarifications from the expert should be tendered in order for the court to be satisfied as to the accused's fitness. And that is what we ask from this court today. Now, I turn next to the issue on jurisdiction, where we argue that this court does have jurisdiction in this case, notwithstanding Sarek's withdrawal from the Rome Statute. Now, the question is whether Sarek's withdrawal affects the court's ability today to exercise jurisdiction. And this issue arises because the formal investigation was authorized by the pretrial chamber after Sarex had withdrawn from the Rome Statute. Thus, the issue is at which point in time the court should ascertain if the state in question is a state party to the Rome Statute. And our submission is that the state must be a state party at the time at which the crimes were committed. This is directly supported by the 2021 pretrial chamber decision in the Philippines at paragraph 111. Now, Your Honours, in the case of the Philippines, the facts were similar to the case before this court today, where the court only authorized the formal investigation on 24th of May 2021, which was after Philippines had already withdrawn 2 years prior on 17th of March 2019. Now, we note that there was an appeal against this pretrial chamber decision in the Philippines, where in the dissenting opinion, it stated at paragraph 26 that the state needs to be a state party at the time the pretrial chamber authorizes the investigation. But our submission is that this dissenting opinion should not be followed by this court today because it could lead to the potential of abuse by state parties withdrawing from the Rome Statute after the commission of crimes and then failing to cooperate with the court. Now, I note that Judge Ahmed had queried the prosecution earlier on whether or not there is an obligation to cooperate on the part of Sarex. And indeed, there is no obligation on the part of Sarex to cooperate with the Office of the Prosecutor's preliminary examination. But this is the very reason why our position on jurisdiction should be preferred. Because given that there is no obligation to cooperate, if a state fails to cooperate with, for example, UNESCO in this case, and simply buy time for more than a year, then the court will not be able to exercise jurisdiction over the crimes.
Counsel, if I may ask a follow-up to that. So if an investigation is authorized by the pretrial chamber after a state has effectively withdrawn, in light of Article 127(2), does the state have an obligation under the statute to cooperate with that investigation?
No, the state would not have an obligation if the investigation was authorized after withdrawal. But this is not fatal to our submissions on Article 127, because Article 127 contains the words matter under the consideration by the court, and this can include the Office of the Prosecutor's preliminary examination. And our support for this can be found in the Rome Statute itself, where in Article 34C of the Rome Statute, it states clearly that the Office of the Prosecutor is an organ of the court, and therefore the preliminary examination that is initiated by the Office of the Prosecutor here before withdrawal can be considered a matter under consideration by the court. Now, this interpretation is also supported by Otto Trifter in his treatise, The Rome Statute of the ICC, at page 2324, where he states that states whose nationals have been the subject of the prosecutor acting with a preliminary examination is likely not able to terminate such proceedings by withdrawing, and that this is the most possible meaning of the words matter under the court's consideration in Article 127 of the Rome Statute. Now, I turn to the issue of the substantive crimes in this case. First, the war crime of attacking protected objects under Article 8(2)(e)(4) of the Rome Statute. We turn specifically to the requirement of intensity for there to be a non-international armed conflict, as stated in this court's 2019 Taganda decision. Now, at paragraphs 28 to 30 of their written submissions, the defense has argued that protractedness is a stand-alone requirement. Now, we acknowledge that Article 8(2)(f) of the Rome Statute contains the word protracted, unlike in the ICTY statute. But the 2016 trial chamber in the Bemba decision at paragraph 139 interpreted this word protracted in the statute to mean that protractedness is merely one of the relevant factors in determining intensity, and that holistically, the armed conflict here can be sufficiently intense regardless of its 2-day duration. Now, the court went on to explain that for conflicts that last for a relatively shorter duration, the court ought to view them not only through the lens of duration, but also through the lens of the number of casualties and the intensity of the violence. This was also held in the court's 2016 Bemba decision. Therefore, Your Honours, even if the conflict in question, which can be found at paragraphs 7 and 8 of Appendix C, only lasted for 2 days, it can still be sufficiently intense because it meets the other factors for intensity. For example, the seriousness of attacks, the increase in the number of reinforcements of both the Carrick's party as well as the municipal security personnel overnight, as well as the fact that the conflict in question caught the attention of international organizations, and UNESCO, at paragraph 9 of the report, had described the events as one of the most egregious forms of cultural cleansing in the 21st century.
Counsel, was it the conflict, the armed confrontation that was described by UNESCO as what you mentioned, or was it the destruction of the archaeological site?
Well, Your Honour, it states at paragraph 9 that, and I quote, UNESCO considers this one of the most egregious cases of cultural cleansing. And our submission is that the court could infer from this that UNESCO was referring to both the events at the site, which was the destruction of the site, but also the fact that there were 800 protesters that were killed at the site. And taken as a whole, this war crime was considered an egregious form of cultural cleansing. Now I turn next to the crime against humanity of persecution, specifically the requirement that there needs to be a systematic attack directed against a civilian population. Now, I note the exchange between Judge Bartels and the prosecution earlier on the characterization of the Carrick's fighters in this case, specifically the prosecution's argument that on one hand, under Article 8, these fighters were an organized armed group, but then for the purposes of Article 7, they ought to be considered civilians. Now, in our response, this distinction is not fatal to our submission because the element of a systematic attack directed against a civilian population is a contextual requirement for Article 7, as was held by this court's 2016 Bemba trial judgment. Now, because of this, when the court considers whether there was a systematic attack, it looks at the context behind the specific persecutory acts in this case. And on the facts, this context can be found from paragraphs 4 to 6 of Appendix C, where Your Honours will find that there was repeated legislation that was targeted against the Carrick's party. Now, it criminalized the possession of the Tiroche artifacts and also banned the Carrick's party from taking part in certain elections. Now, these are acts that were indeed directed against civilians because there is no indication that all of the 100,000 Carrick's party members took up arms or bore arms against the state.
Counsel, if I may, can non-physical, non-violent measures taken by a state constitute an attack against a civilian population?
They can indeed be considered an attack, even if they are non-violent, and this was held both in this court's 2016 Bemba trial judgment, as well as this court's 2014 Katanga trial judgment. So notwithstanding the fact that the laws against the Carrick's party on the facts were non-violent, they can be characterized as the contextual element of a systematic attack directed against a civilian population in this case. Now I turn next to the Judge Bartels. I note that you have a question.
Thank you. Counsel, you've now been talking about both the attack, the alleged attack, and the existence of a civilian population. If we turn to the specific wording of the crime that is alleged by the prosecution, it also requires that there's a connection with any act referred to in this paragraph or in any crime within the jurisdiction of the court. What crime is connected to the charge here?
The crime that is connected to the charge of persecution in this case is the war crime of attacking protected objects that is found under Article 82E4 of the Rome Statute and is a crime within this court's jurisdiction. And because we see that both of these crimes were perpetrated by the same group, that being Mr. Strong and the Cyrex government, they can meet this requirement under Article 71H of the Rome Statute.
Now, on that issue, because I expected that response, because both crimes have indeed been charged at the same time, the killing of the protesters took place prior to the destruction. Can the crime already have been connected to something that hadn't taken place at that time? How does that work?
Your Honor, we say that it can take place, that the element can be satisfied even if the killing of the protesters took place before the crime had occurred, which is because the nexus requirement for a war crime, which requires that the perpetrators must have directed the attack and intended such an attack against the protected objects, took place before the attack against the protesters. And this can be found at paragraph 7 of Appendix C at the first line, where Mr. Strong had originally already ordered the destruction of the site before the armed conflict had even occurred. Now I turn lastly to the element of a discriminatory intent on the part of the perpetrators for the crime against humanity of persecution. Now, according to this court's 2021 Ongwen decision, this requires that there was a discriminatory intent targeted against a specific group on a specified ground. And in our submission, Mr. Strong did possess such a discriminatory intent against the protesters in this case. At paragraph 7 of Appendix C, Your Honours will find that he ordered deadly force to be used against the protesters who were likely armed with handguns and bats. Now, he ordered this deadly force to be used knowing that his security personnel were armed with rocket-propelled grenades and rapid-fire assault rifles. Now, in response to the protesters, he did not use any means of gradual escalation against the group, but instinctively resorted to the use of rocket-propelled grenades. This disproportionate use of force is an indication of his discriminatory intent, as was held by the 2001 ICTY trial judgment in Dordovic. Now, because of this, the element of a discriminatory intent in this case can be satisfied. This brings me to the end of my submissions, unless there are any further questions from the bench. Thank you.
Madam President, Your Honors, good day. Before I begin with my submissions, it is at this point that we would like to emphasize that society has an interest in seeing that convictions are secured fairly and not just because of a defendant's helplessness at trial. Article 67 of the Rome Statute guarantees that a defendant must be tried with full respect for his rights and dignity. Therefore, today I stand before you not only to represent the defendant, but also to ensure our faithful adherence to the Rome Statute. Your Honors, I have 3 submissions before you today. First, that this honorable court lacks jurisdiction over the defendant. Second, that the allegations and evidence are insufficient to establish substantial grounds to believe that the defendant committed a war crime or a crime against humanity under the Rome Statute. And finally, that the defendant is not fit to stand trial. Proceeding to my first submission, Your Honors, we support this by establishing 2 points. First, that at the time this court exercises its jurisdiction, Cyrex must be a state party to the Rome Statute, which was not met in this case. And secondly, a preliminary examination solely conducted by the prosecutor is not a matter under consideration by this court under Article 127. Proceeding to my first point, Your Honors, reading Articles 12 with Article 13, paragraph C rather, with Article 15 of the Rome Statute would show that a prosecutor initiates a motu proprio investigation by submitting a request before the pretrial chamber for an authorization to commence an investigation. And this court exercises its jurisdiction by authorizing the said request. However, Article 12 of the Rome Statute provides that certain preconditions must be met first before this court can exercise its jurisdiction. It is our submission that these preconditions must exist at the time this court exercises its jurisdiction and not just at the time the crime was committed. We support this, Your Honors, with 3 reasons. Firstly, a contrary interpretation would render Article 127, paragraph 2 a nullity, for there would have been no need for the drafters to qualify that certain obligations would survive a state party's withdrawal. Secondly, a plain reading of Article 12, paragraph 2 supports this, as the intentional use of the present tense verb are would indicate the drafter's intent that the assessment of the preconditions must be contemporaneous. Furthermore, Your Honors, a contrary interpretation would undermine the fundamental principle in international law enshrined in Article 34 of the Vienna Convention on the Law of Treaties, that states should not be bound by obligations they did not consent to. We would like to emphasize that the drafters of the Rome Statute rejected the idea of universal jurisdiction, thereby emphasizing that state consent is paramount. We would also like to submit, Your Honors, that our interpretation achieves the perfect balance between the right of the states to withdraw from the Rome Statute as guaranteed by the statute itself, as well as the duty of the prosecutor to effectively prosecute crimes before this court. Your Honors, we acknowledge this court's pronouncement in the situation in the Philippines. However, we would like to highlight in paragraph 55 of the Appeals Chamber's decision that the Appeals Chamber did not consider the impact of the Philippines' withdrawal from the Rome Statute, as this was not adequately ventilated before the pretrial chamber. In contrast, in the present case, Your Honors, the issue precisely rises on the interpretation of a matter under consideration in Article 127, paragraph 2. And on this point, it is our submission that the preliminary examination established by the prosecutor on the Republic of Cyrax cannot amount to a matter under consideration under Article 127, paragraph 2.
So supporting this contention?
Your Honor, while currently there is no case law supporting this contention, we forward that this interpretation is supported by the Vienna Convention on the Law and Treaties. We begin with the ordinary meaning of the term the court, and we note that this refers to a tribunal presided by judges. This ordinary meaning is further confirmed by the context of the term. The exact phrase under consideration by the court can only be found in Article 95 of the Rome Statute, which, if we read the provision, Your Honors, specifically refers only to the chambers of this court, excluding the office of the prosecutor. We also submit that this interpretation is consistent with the object and purposes of the Rome Statute to effectively prosecute crimes before this court. Your Honors, if we consider a preliminary examination to already amount to an engagement of this court's jurisdiction, then this would be tantamount to altering the carefully crafted jurisdictional regime of this court, as we would like to emphasize that based on the travaux of Article 15 of the Rome Statute, the drafters were concerned of an all too powerful prosecutor. Thereby, they placed a safeguard in the form of an authorization by the pretrial chamber. Furthermore, Your Honors, we note that the Office of the Prosecutor itself recognized that there is no duty to cooperate on a preliminary examination, and their policy paper itself emphasizes that it cannot employ its full investigative powers during a preliminary examination. Therefore, Your Honors, because of these reasons, we submit that the preliminary examination cannot amount to a matter under consideration, and therefore, the Republic of Cyrax in this case can no longer be bound by the jurisdiction of this court.
Counsel, if I may, there have been disparate arguments about the object and purpose of the Rome Statute. The prosecution and the CLRB argue that considering preliminary examination as a matter under consideration would be in conformity with the object and purpose. How does your interpretation of object and purpose of the Rome Statute counteract that?
Your Honor, we would like to submit that part of the object of the statute is the effective prosecution of crimes. And underlying this effective prosecution is the capacity of this court to enact cooperation by the states. And interpreting Article 127 to a contrary manner would then amount to arriving at an interpretation of the statute that the states did not consent to. Therefore, Your Honors, at any rate, we submit that any abuses to this to this provision could be allayed by the one-year period provided in Article 127, paragraph 2 itself, within which can allow the prosecutor to initiate an investigation prior to the effectivity of a state party's withdrawal. Your Honors, if there...
Counsel, you've already mentioned the appeals chamber's decision in the Philippines. But effectively, you're asking us, the appeals chamber, to depart from this previous jurisprudence. What is your basis to suggest that a departure is warranted, the legal basis for the departure, not the arguments you've given before?
Your Honor, the appeals chamber in Bago explained that while the appeals chamber do not readily depart from its jurisprudence, it can do so when there are convincing reasons to do so. And here, Your Honors, we submit that the earlier mentioned reasons, based on an interpretation of the provision on the Vienna Convention on the Law and Treaties, would suffice as convincing reasons for this court to depart from its previous jurisprudence. Your Honors, if there are no further concerns, I will now move on to my second submission. Your Honors, we first turn to the charge of war crime. It is our first submission that a non-international armed conflict does not exist in this case because the fighting is not protracted, it is insufficiently intense, and finally, the Caraxes Party is not an organized armed group. Turning first to protractedness, Your Honors, Article 82F of the Rome Statute specifically provides that crimes under Article 82E should apply to a protracted armed conflict. And different chambers of this court, such as in the case of Al-Hassan, for example, considered a fighting as protracted when it lasted for a year, in Bemba when it lasted for 4.5 months, and in the situation in Ivory Coast when it lasted for 2.5 months. None of these cases, Your Honors, are analogous to the case at Bar, considering that the fighting only lasted for 2 days, and therefore it cannot satisfy the threshold of protractedness met in this court, Your Honors. In addition to this, Your Honors, the fighting is also insufficiently intense. The trial chambers in Katanga and Lubanga explained this requirement as that a non-international armed conflict must exceed that of internal disturbances or sporadic acts of violence. And in assessing this requirement, Your Honors, the frequency of the attacks, as well as the spread of the attacks over other geographical locations, are considered. Here, Your Honors, there were only 2 instances of attacks, one on June 8, 2021, and the other on June 9, 2021. And in addition to this, Your Honors, the fighting was only isolated and confined on the airport construction site. Therefore, it cannot be considered as sufficiently intense. Turning now, Your Honors, to the organization of the Caraxes Party. The trial chambers in Katanga, Lubanga, and Bemba explained that this requirement refers to the capacity of the group to maintain protracted armed violence. Several factors were considered in previous cases, Your Honors, which I will discuss in turn. Firstly, A relevant factor is the internal hierarchy structure as well as the command structure of the group. To contrast this, Your Honors, in the case of Katango, for example, the court considered that the armed group had different constituent troops located in different geographical locations, and then they had the capacity to implement a military strategy. In contrast here, Your Honors, there is only evidence that there is one leader, figurehead in the form of Alinda Jasper, but there is no other evidence that the group is capable of maintaining protracted armed violence by having the capacity to have a constituent troops as previously decided in other cases. Furthermore, Your Honors, the fact that there is no showing that they had the capacity to implement a military strategy can be shown by the lack of military strategy, even if they were able to arrive at the site the next day with more people. However, they were still unable to enact any different strategy to be able to respond to the municipal security forces.
Counsel, if I may, is there a difference between bad military strategy and lack of a military strategy here?
Your Honor, while there is, we submit here that there is a lack of military strategy, as there is no showing on the facts that the protesters were in fact able to plan any strategy, as they only arrived at the site as a result of the urging of the leader. This can be reasonably inferred as only a spontaneous reaction to the outcry of one person. Because of this, Your Honors, we submit that the Caraxes Party cannot be considered as an organized armed group, as they were unable to maintain protracted armed violence. Turning to our second submission under the war crime, Your Honors, we also submit that the site in this case cannot be considered as a historic monument. In the case of Almaty, Your Honors, the court considered a site to be a historic monument if it played an integral role in the community, in the cultural life rather of the communities in that case. And to illustrate this, Your Honors, in Almaty, the residents of the communities continuously visited the site, and even families depended, and even the incomes of some families depended on the site. In contrast here, Your Honors, there is no showing that the archaeological site played an integral role in the cultural life of the members of the Caraxes Party or of the peoples of the government of Cyrax. I see that now.
Yes, Counsel. The site was only just discovered. Is the ability to visit a site, is that indicative of its cultural value, or should there be other indicators?
Your Honor, we submit that while physical connection with the site is not necessary, there has to be some showing that the members of the Caraxes Party consider the site to be culturally significant for them. And here we would like to highlight that it was long believed, based on the record, that the site was located on the airport construction site. However, the members of the Caraxes Party did not move or did not provide any advocacy in order to highlight the cultural significance of this site. Because of this, Your Honors, we submit that the historic monument in this site cannot be considered to be culturally significant to warrant protection under the war crime.
All right. Counsel, whether or not it was historically relevant to the Caraxes may be something for consideration for the other crime that's charged. But is it a subjective relevance that needs to be considered for the war crime, or is it an objective finding of something being an historic monument or relevant?
Your Honor, we submit that it is an objective finding, as the elements of a war crime under Article 82E4 only protects historic monument. And here we submit that the site is not a historic monument. Your Honors, we now turn to the crime against humanity of persecution. We submit that the defendant did not target the members of the Caraxes Party.
Counsel, so sorry. Before you move on, what of UNESCO's rule with respect to this finding of historical monument?
Your Honor, in the case of Almaty, the designation of the sites as a World Heritage Site were considered as evidence of the role of the site to the cultural life of the people, and therefore it can be considered as a piece of evidence in determining the status of the site as a historic monument. Your Honors, in the charge of persecution, we submit that the defendant did not have discriminatory intent in ordering the demolition and the resistance of the fighters in this case. The trial chamber of Nojalak and Ongwen explained that the perpetrator must consciously intend to discriminate the people with regard to the alleged conduct. And here, Your Honors, we must look at the context of the defendant's acts only. Here, he ordered the demolition of the site because it was long planned by the Cyrax Parliament that an airport was to be constructed on the same site where the archaeological site was discovered. Furthermore, Your Honors, his order to resist the protesters must be seen in light of the fact that the protesters arrived at the site armed, and the protesters were members of a terrorist group. Therefore, it could be reasonably inferred that the defendant only ordered the said resistance in order to protect its national security and public order. Because of these reasons, Your Honors, we respectfully submit that the defendant did not intend to discriminate the members of the Caraxes Party.
And what do you say with respect to the disparity of weaponry?
Your Honor, we respectfully submit that at the time on the record, the Caraxes Party had potentially 100,000 members. And therefore, when the defendant ordered the municipal security forces to be armed with the same weapons, he reasonably inferred that maybe more than or most of the 100,000 members would come to the site, and therefore they only had their weapons coming for them. Your Honors, I will now move on to my third submission. We respectfully submit that the defendant in this case is not fit to stand trial because he cannot meaningfully participate in the proceedings in this case. In the decision to stand fitness on Al-Hassan, the court considered meaningful participation, such as the defendant should be able to effectively exercise his fair trial rights during trial. And in the decision of this court on the fitness to stand trial of Bagbo, the court cited the European Court Human Rights case of SC versus United Kingdom to further emphasize this point. And meaningful participation in that case was the capacity of the defendant to listen to the witnesses presented during trial, point to any inconsistencies of on their statements, and then provide his counsel with relevant information that could potentially help his defense. However, Your Honors, Dr. Baleron's report show that the defendant has complete memory loss of the alleged events. Therefore, he will not be able to provide any piece of evidence that could potentially help his counsel form a defense that could help his acquittal. As to the method used by Dr. Baleron, we would like to respectfully highlight that the reliance of the pretrial chamber on a medical expert's report is discretionary. And this discretionary decision can only be overturned by this appeals chamber if there is an abuse of the said discretion. However, Your Honors, here there is no showing that the pretrial chamber abused the said discretion. Your Honors, may I respectfully request for a minute extension to complete? Yes. Your Honor, I notice that you have a question. Yes, okay. Your Honors, because of this, we would also like to highlight that in previous decisions of this court on the fitness to stand trial of a defendant, such as in Al-Hassan and Bagbo, the court accorded deference on the chosen methodology of the expert. And here, Your Honors, we would like to highlight that the chosen methodology of Dr. Baleron should be accorded deference, given that her competence was never questioned before the pretrial chamber, and she is also part of the registry of experts before this court. Because of these reasons, Your Honors, we respectfully submit that the defendant is not fit to stand trial. We therefore humbly request this appeals chamber to affirm the findings of the pretrial chamber. Thank you, and may please the court.
Thank you very much, Counsel. All right, so very important, very strident points have been raised by all the parties and participants. So now, each party will now be given in the same order in which the statements were given in the first place, the possibility to reply. I'd like to remind you of the time allocated, which is 10 minutes for this rebuttal. Counsel for the prosecution, you may begin now.
Judge President, Your Honors, good morning again. We shall make 3 points in rebuttal. That contrary to the defense submission, Article 127.2 cannot be given a restrictive interpretation. Second, that the lack of a military strategy in this case is not enough to render the group to be insufficiently organized. And lastly, that the defendant in this case can still meaningfully participate despite his lack of recollection of the material events in question. Turning to our first point of rebuttal, Your Honors, whenever provision of the Rome Statute comes up for interpretation, we must remember that the English language is not an instrument of mathematical precision. And this is why the court has always been guided by the object and purpose of the provision in question. For example, in the Article 19.3 decision in the situation in Bangladesh, the court was guided by the object and purpose to determine the scope of provision of Article 12 of the Rome Statute. For example, again, in the pretrial chamber in the confirmation of decision in DRC, the court was guided by the object and purpose to determine the scope of Article 83 of the Rome Statute. In this case, the defense argues that the object and purpose of Article 127 is effective prosecution. However, Your Honors, we must note that this is a broad purpose that is in line with the whole Rome Statute. And while assessing the scope of a provision, what we need to assess as per Article 31 of the VCLT is the object and purpose of this particular provision in question. And as shown by the prosecution, the drafting history of Article 127.2 of the Rome Statute, as evidenced by the draft Article 98H, was to make sure that states cannot escape accountability through withdrawals. And that therefore, Your Honors, the object and purpose in this case is to make sure states like the Republic of Syriac do not escape accountability. But at it, we also note that the defense has also placed reliance on Article 95 of the Rome Statute, to the effect that this is the only article in addition to Article 127 that discusses about matter under consideration. We note that the provisions of Article 95 regards admissibility challenges. However, as we'll note with regards to the provision of Article 127.2 of the Rome Statute, it is broad enough and it extends beyond admissibility challenges. And therefore, Article 95 in this case cannot be invoked to adopt a restrictive interpretation of Article 127.2 of the Rome Statute. And in light of this, we do submit that this was a material error of law in the interpretation of Article 127.2 of the Rome Statute. And in light with Rule 158.1 of Rules of Procedure and Evidence, this court should reverse the decision of the pretrial chamber. Turning to the second point of consideration, the defense in this case has largely argued that there was lack of a military strategy within the Karaxis fighters. A military strategy as defined by the Katanga trial judgment includes military action geared towards providing a military advantage towards the attacking party. In this case, as evidenced in the Interganda trial judgment, assessing a military strategies can be generally assessed from the mode of attack. How is the attack conducted? And in fact, in case of Interganda, the fact that the UPC soldiers could attack the Mugalu villages in 2 phases was found to show the existence of a military strategies. And similarly, in this case, the group in question did attack in 2 phases. The first group attacking on the 8th of June 2021, comprising of 800 attackers. And the second group did join in on the 9th of June 2021, comprising of additional 1,200 Karaxis fighters. And therefore, Your Honors, as per the standard of Interganda of attacking villages in 2 phases, this indicates the existence of a military strategy in this case. And it's also worthwhile noting that the defense in this case has not provided a metric of evaluation of the existence of a military strategy. Lastly, Your Honor, regarding the issue of fitness to stand trial, we note that the defense in this case has placed reliance on the backbone on the back of fitness decision of 2012, in particular our paragraph 47, that requires that the accused, while represented, is required to give his own version of the events. However, that same decision, in particular at paragraph 51, the court did state that where a health defect, that where the accused person has a health defect, the court should consider the existence of mitigating circumstances that can be made or applied in order to help the accused person to participate effectively. In this case, we do submit that there is an existence of mitigating circumstance. For example, Your Honor, if the concern in this case is to recall the events of 8th and 9th of June 2021, pursuant to paragraph 1 of Annex C to the record, there's other types of evidences, such as smartphone recordings, smartphone videos, and even further to this documentary evidence documenting the happenings of June 8th and June 9th, 2021. And even further to this, the accused person in this case has his counsel, as well as the wife was given a power of attorney. And this can help the accused person to effectively participate in the trial. However, even if this court is not to agree with the prosecution on this point, we still submit that the pre-trial chamber did in terminating the proceedings pursuant to Rule 135.4 of the Rome Statute. Rule 135.4 of Rules of Procedure and Evidence. Rule 134 of Rules of Procedure and Evidence provides that where there is a finding of unfitness, this court should not terminate the proceedings, but rather it should adjourn the proceedings and do a periodical analysis or review of the health status of the accused person within a periodical review of 120 days. Your Honor, I know you have a question. Thank you.
I'll go ahead. So the defense is arguing that decision with regard to termination of proceedings, appointment of the expert, consideration of the expert report is exercise of the pretrial chamber of its discretion. And only instance where the appeals chamber can interfere is when there's an abuse of discretion. So what is the basis, or is there any basis for an abuse of discretion here?
Yes, Your Honors, as per standard of appellate review evidence in Article 83.2 of the Rome Statute, an abuse of discretion will be evidence where the pretrial chamber will not, where this appeals chamber will not arrive at a reasonable conclusion similar to that arrived at the pretrial chamber. And the standard here is that of reasonableness. And in this case, we do submit that it was unreasonable for the pretrial chamber to terminate the proceedings for the following reasons, Your Honor. Your Honor, first, the rules of procedure under Article 135.4 should be better seen as placing an obligation on the chamber to determine the right of the accused person to participate effectively in the trial. So regardless of whether we are at the pretrial chamber or appeals chamber, this court has an obligation to make sure that the accused person can meaningfully participate in the trial. Second, in light with the particular circumstances of this case, it was unreasonable for the pretrial chamber to terminate the proceedings. As argued by the OPCV, the PTC only relied on one report, whereas we are cognizant that there is no legal requirement that there must be more than one report. When you look at the jurisprudence of this court, for example, in the case of Prosecutor versus Alassane, there was 3 medical experts, meaning there were 3 reports. In the case of RMCT, in the case of Kabuga before the RMCT, there were 5 experts, meaning there were 5 different reports. And when you look at all these reports, the experts have never agreed on one point of conclusion. And this therefore would show that one report is not sufficient for the chamber in this case to arrive at the conclusion of unfitness. And second, and the last point, Your Honor, is that there was a manifest error of fact in this case. The pretrial chamber did state that the accused was permanently unfit to stand trial. However, as per the expert opinion of Dr. Baleron in this case, the accused person, the expert does state that it is highly improbable that the accused person is unlikely to regain fitness. We submit that highly improbable and impossible, these are 2 different synonymous standards. And this was actually the basis of which the pretrial chamber did rely on to terminate the proceedings. An error of fact missed on this. In conclusion, Your Honors, the prosecution and the defense may tussle all day long, but 2 factors will remain in this case. First is that there was the death of more than 800 individuals. And second is that there was destruction of the Tirosh archaeological site. We urge this court to reconsider the systematic implication of its judgment. If this court is to adopt the rationale given by the defense, this court would be opening a doorway to impunity, where state would always withdraw when a preliminary examination is launched. And this, Your Honors, we submit, it is not in the interest of justice, it is not in the interest of this court pursuant to the objected purpose of this court. And therefore, in light of this, we persuade this court, in light of the submission given by the prosecution, to rule in favor of the prosecution. And that concludes the submission, unless there are other further questions by the bench.
Thank you, counsel. I do have one short question. The defense put forward the argument that the time period was too short. It was not protracted. And in the defense argument, the 2 days was too short, and the argument put forward that was that the shortest possible time was, I think, 2.5 months. What do you say of this?
Your Honors, I know that my time is up. Could I kindly answer your question, ask an extension to answer your question?
Yes, please, in 2 sentences.
Thank you. Your Honors, the standard of protracted is not limited to duration. It extends to other intensity factors. And as we did submit, the ICC Tadich Appeals decision in 1999 elaborates protracted to include other intensity factors and not limited to duration. And this standard has actually been adopted by this court in the Interganda trial judgment, in particular at paragraph 704.
All right, counsel, thank you. Yes. All right, so now may I ask the counsel for the legal representative of the victims? Please, may we have your reply?
Madam President, Your Honours, I have 5 points in rebuttal today. The first point in rebuttal pertains to the issue on jurisdiction, specifically the arguments on Article 127 of the Rome Statute. Now, both the prosecution and the defense counsel today have heavily relied on interpretation through the Vienna Convention of the Law of Treaties, specifically that a treaty should be interpreted in light of its object and purpose. But the Vienna Convention on the Law of Treaties says that interpretation must also be done in good faith. Now, the defense has argued today that any concerns of abuse by state parties can be mitigated by the 1-year time period found in Article 127. But what they fail to bring up for this court is that on the very facts before the court today, this 1-year time period was insufficient for the Office of the Prosecutor to complete its preliminary examinations, and therefore the defense cannot argue that there will be no such abuse, and their interpretation of the treaty in question is not made in good faith, and that there are no convincing reasons why this court should depart from the established jurisprudence both in the cases of Philippines as well as the case of Burundi. Now I turn to the second point of rebuttal, specifically the requirement of protractedness. And I note the question that Madam President had posed to the prosecution counsel earlier on the fact that the shortest duration that this court has found in armed conflict is 2.5 months. Now, the defense in their main submissions had argued on the case of Bemba, which was a case where the conflict was 4.5 months. But what they failed to highlight is that in the case of Bemba, there were 1,000 deaths over a period of 4.5 months. But in contrast, Your Honours, on the facts before this court at paragraph 7 of Appendix C, Your Honours will find that were 900 deaths within the period of 16 hours. Now, this shows that intensity cannot be a requirement that is only boiled down to protractedness, but requires a holistic appreciation for other factors, for example, the number of casualties, as well as the fact that the events attract the attention of international organizations. And this holistic approach has been endorsed by this court in its 2016 Bemba decision. Now, I turn next to the third point of rebuttal on the defense's arguments that the objects in question were not protected under Article 8. Now, I note the exchange between the bench and the defense earlier, to which the defense replied that on the facts, the Carrick's party must believe that the site is significant and that they did not provide any advocacy in favor of protecting the site. But this fails to consider certain relevant facts in Appendix C. For example, at paragraph 5, Your Honours will find that the very purpose of the Karaxis Party was to protect the Tirosh archaeological site, and that at paragraph 7, despite being denounced as terrorists by their own government, they were willing to show up at the site to protect the site. Now, these actions clearly show that the artifacts at the site were treasured by the Karaxis Party members, and therefore, according to the defence's own definition of a protected object, the objects in question were indeed protected. Now, I turn to the fourth point of rebuttal on the defence's arguments on Article 7 of the Rome Statute, specifically their argument that the protesters here were part of a terrorist group and therefore there was no discriminatory intent. Now, I note that Madam President had pointed out the disproportionate nature of the response to the protesters, to which the defense had replied that the Karaxis Party has 100,000 members. But this again fails to consider the facts before this court, which are that at paragraph 7 of Appendix C, there were 800 armed protesters against 1,000 municipal security personnel, and that on the second day, there were 1,200 protesters against 2,500 municipal security personnel. Now, despite of this, Mr. Strong ordered deadly force in the form of rocket-propelled grenades to be used against the protesters. I know that you have a question, Judge Patel.
Yeah, Counsel, thank you. This question builds on to something you mentioned in your initial pleadings, but you used the word proportionate again now in your rebuttal. If the protesters qualify as fighters, as was argued at least by the prosecution and to a certain extent by you in your initial pleadings, in order to come to the classification of a non-international armed conflict, is there a need for force to be proportionate? Could the security forces only use the same weapons, handguns and bats? Or is there any requirement that force against fighters has to be proportionate?
Yes, Judge Patel, there is a requirement of a proportionate use of force. And our authority for this is the 2001 ICTY decision of Dordovich, where in that case, the court found a discriminatory intent based on the facts, which showed that there was a discriminatory and disproportionate use of force against a particular terrorist group, that being the Kosovo Liberation Army. Now, despite the fact that the group being persecuted was a terrorist group, the court still found persecution on the basis of the disproportionate use of force, the types of weapons used in the operation, as well as the high number of KLA casualties. Now, similarly, Your Honours, on the facts before this court, we can also find that there was such a disproportionate use of force, given that Mr. Strong had ordered deadly force in the form of rocket-propelled grenades against the 800 protesters. Now, I turn lastly to the fifth point of rebuttal on the issue of fitness in this case. Now, I note that Judge Ahmed had earlier queried the prosecution on the decision to terminate proceedings or the decision by the lower court to refer to Dr. Beleron's report, and how this is a matter of discretion by the lower court. And this was also argued by the defense counsel earlier. And the prosecution had replied that the standard of appellate review can be found at Article 83 of the Rome Statute. Now, we further add to that what amounts to something that this court today can overturn is where there was an error of fact by the pre-trial chamber, and this occurs when there is a misappreciation of the facts before this court. And before this court today, there is a simple reason why there was such an error of fact, which is that based on the evidence before this court found in Dr. Beleron's report, there is insufficient evidence to show conclusively that Mr. Strong is permanently unfit to stand trial. And this is because of both the lack of details provided by Dr. Beleron in the report, as well as the lack of reasoning for her conclusions in the report. Now, I note the defense counsel at the start of their submissions had argued that society has an interest in ensuring that accused persons are tried fairly. Now, we can agree with this proposition, and in fact, it was cited in the 2023 Kabuga decision. But what is also important for this court is to acknowledge that before we can get to that stage, there must be sufficient evidence for this court to be convinced that the accused is even unfit to stand trial in the first place. And our submission is that based on the solitary report before this court, there is insufficient evidence to show that Mr. Strong is permanently unfit to stand trial. This brings me to the end of my rebuttals. Thank you.
Thank you, counsel.
Good day, Your Honors. We have 4 points for our rebuttal. The Victims' Counsel argued that the interpretation based on the Vienna Convention on the Law on Treaties must be done in good faith. Your Honors, in this case, the Victims' Counsel also cited the situation in Burundi. However, it must be emphasized that in that particular case, the prosecutor sought authorization and the pretrial chamber authorized the commencement of an investigation prior to the effectivity of Burundi's withdrawal. Furthermore, Your Honors, it has been shown by the Office of the Prosecutor in the past that the 1-year period is enough to complete a preliminary examination, as was in the case in the situation in Libya, as the prosecutor completed the preliminary examination for 5 days, as well as in the situation in Darfur, wherein the preliminary examination was completed in 2 months. Therefore, Your Honors, any fear that Article 127, Paragraph 2 would be abused is unfounded. Secondly, Your Honors, we would like to address the Victims' Counsel's argument on protractedness. We would like to highlight that it is explicit in the Rome Statute that crimes under Article 82E4 must apply only to protracted armed conflict. And consistent jurisprudence of this court has always considered the duration of the fighting as an indispensable factor when assessing the existence of a non-international armed conflict. Turning now, Your Honors, to our third point, the prosecution argued that there must be accommodations and other pieces of evidence that can be used during the trial for the defendant. However, Your Honors, we must emphasize that the defendant in this case has complete memory loss of the alleged events, and the crimes charged against him has mental elements. Therefore, the knowledge of the defendant as to the crimes charged against him is important during the trial for the crimes charged against him. Because of his complete memory loss, Your Honors, he would not be able to meaningfully participate during trial, which is the standard in assessing whether the defendant is indeed fit to stand trial, as provided by this court in Al Hassan. Furthermore, Your Honors, the Victims' Counsel pointed out that there is an error in the appreciation of the pretrial chamber of Dr. Baleron's report, as Dr. Baleron's report does not provide for sufficient evidence in her conclusion that the defendant is not fit to stand trial. Your Honors, while Dr. Baleron could have provided more explanation as to her conclusion, we would like to highlight that the report itself contains the medical history of the defendant, which, according to the guidelines for forensic psychiatric evaluation for competence of the defendant to stand trial, is an important consideration in assessing the fitness of the defendant.
Counsel, if I may, what is the standard that chambers are to apply when assessing sufficiency of expert evidence?
Your Honor, based on Rule 135 of the Rules of Procedure and Evidence, the standard in this case is that the satisfaction only of the chamber before this court. And this satisfaction means that it is entirely based on the pretrial chamber's discretion, whether it is already satisfied that the appointed expert has assessed the defendant's fitness to stand trial. And here, Your Honors, the pretrial chamber was indeed satisfied with Dr. Baleron's report that the defendant is not fit to stand trial. At any rate, Your Honors, the conclusions of Dr. Baleron is consistent with medical reports that stroke-induced amnesia does indeed result in reduction in the competence of a defendant and can significantly affect a defendant's competence at trial. Your Honors, because of the... Yes.
Counsel, given that we're on the issue of the findings in the report, even if we take the report as it is, that there is and this was a point of that the prosecution raised, a permanent or a highly likely permanent memory loss. There are other cases where a defendant doesn't remember what happened during an alleged crime. Drunkenness, other forms of intoxication. Does that affect the ability to stand trial? And in relation to that, you indicated that because there are mental elements here at play, obviously there will always be a mental element that needs to be proven in these criminal trials, but they're generally not proven by questioning the suspect. Does the ability to question the suspect, which is not common in international criminal trials, have any effect on the possibility for the prosecution to prove its case or for the defense to defend its case?
Your Honor, as to the first part of your question, we do acknowledge that international tribunals have had defendants in the past with memory loss, such as in the case of Strugar and Thirith. However, this case must be distinguished from those cases because in those cases, there were certain memory preserved. In contrast here, Your Honor, there is complete memory loss. Therefore, the defendant would not be able to supply any relevant information as to his defense. As to the second part of your question, Your Honor, we do agree that inferences are made when assessing the mental element of the defendant. However, meaningful participation during trial also includes the capacity of the defendant to rebut those inferences and to offer any explanation as to the other as to his conduct in question. And here, Your Honors, given that he could not remember the events, the alleged events on the record, then he would not be able to offer any explanation or rebut the inferences made as to the mens rea element of the crimes charged against him. Because of these reasons, Your Honors, we respectfully ask this appeals chamber to affirm the findings of the pretrial chamber. While we hear the call for outrage, Your Honors, subjecting a person who cannot recollect the events and who cannot meaningfully participate his fair trial rights is not accountability at all. The Rome Statute precludes us from subjecting such a defendant to a long and arduous trial. Therefore, Your Honors, we humbly request you to affirm the pretrial chamber's decision. Thank you and may it please the court.
One question. You had stated that the appeals chamber should give deference to Dr. Valerian's report and the discretion of the pretrial chamber to rule upon the report. But is the appeals chamber bound?
Your Honor, the appeals chamber is not bound by the pretrial chamber's decision as it can overturn a discretionary decision if there is an abuse of the said discretion. Thank you, Your Honors.
All right. This is as difficult as any trial I have ever sat on. We will now leave the court to proceed with deliberations. I cannot say for certain what length of time we would need, but it is best that all parties be present by latest, let's say, 11:45. You may have to wait a bit, but please be seated here by 11:45. All right. Thank you very much, court officer.
All rise.